Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are in Calloway County with attorney Jeff Roberts, and today we're going to talk about some important workers' compensation forms that you may actually have received or that you're probably going to receive from the insurance company once your claim gets started. Jeff, how you doing, guy? Good to see you.
Doing good. How are you?
Oh, I'm doing fine. It's always good to see you down here. And, last month we put out an episode that talked about a Social Security disability form, a 3369, which is something they do in terms of work history. But we thought we'd switch it up and come back to the workers' comp side of it and kind of talk about some of these forms. And these two forms are pretty important. The first one is this designated physician's form. Let's kind of break that one open, and I'll put a link to that form in the show notes so that if people want to get a visual on what this is, or if they actually want to download it for themselves, they'll be able to.
Sure. The designated physician form, or Form 113 is what we commonly refer to it, is a form that someone, when you're injured on the job, it's one of the earlier forms that you will be sent by the insurance company. When you start receiving medical treatment, the insurance company will send you a couple of forms, one of which should be the Form 113 Notice of Designated Physician. And what that form is you're specifying that you want a certain doctor to be what's commonly referred to as your gatekeeper doctor. And that means that's the doctor that, is going to initially kind of provide a treatment plan for you and will be involved to some extent as far as your treatment going forward.
They're going to kind of serve as the quarterback because there could be other specialists involved as well.
Exactly. And what I see frequently is, especially, there are some local employers that like to send their workers to a certain doctor or a certain medical clinic, occupational medicine or something of that nature. And then they want you to designate that clinic as being the designated physician. And the way Kentucky law is, once you make that first designation of who your designated doctor is, you can change that designation one time without the insurance company's approval. Any other change in that designated physician after that first change, then the insurance company has to approve it. So you cannot make a second change unless the insurance company says, okay, we're fine with this change to this doctor. So they have some control over it at that point. Now, under Kentucky, go ahead.
I was going to say, because they may argue the point and say, no, you're not going to be able to use that doctor for whatever reason. They want you to stay with somebody that they have a little bit more influence or control over or relationship with.
A little bit more of a relationship with, exactly, from that standpoint. And, and that's part of the problem I see when I get involved in a case later on and somebody's already changed one time. Then we need to make another change, and it's difficult. And what I see occur frequently is what I consider to be a misuse of the process by the insurance company, and that is, the person initially goes to occupational medicine or whatever doctor their insurance company sends them to, and they have the person designate that doctor as their designated doctor, and then that doctor sends them to the company orthopedic surgeon or company specialist, or at least the specialist that has somewhat of a relationship with that insurance company, and then they make them change to that specialist as the second designated doctor. And then even if the insurance company requests that they make that change to the second designated, you've changed that one time, and then any other change has to get insurance company approval.
In previous episodes, we've talked about there's a lot of gamesmanship, and in this particular game, 2 strikes and you're out, and that's kind of what they've done is they've caused you to make a change and then maybe make another designation, which uses, like you said, puts them right back in control of this.
It puts them in control of your medical treatment, And you don't want that to occur. One of the best things about Kentucky's workers' compensation law is that the injured worker gets to choose their medical providers. And that is not only the doctors you see, but the physical therapy you go to. If you have to have diagnostic studies such as MRIs, you get to pick where you get your MRI done at. And I've had them try to send my clients here in Western Kentucky down to Nashville to get an MRI because they could save $100 on it. My client's got to drive 2 hours to get the MRI, and that's not reasonable. And so the injured person gets to pick who their treating doctors are. Well, if the insurance company if the employer sends them to their chosen provider, and there's some companies still tell their clients, if you don't go to who we tell you to, then we won't pay the bill. That's not Kentucky law. That's not the case. There's one employer here in Western Kentucky. I won't mention their name, but I've had them sanctioned before over that kind of conduct. They still tell their clients that, and I can guarantee you on my clients who've treated with other people, they paid the bill ultimately in that situation. So that's not true. But they will try to threaten people, so they go to the doctor that they want them to go to, and then they get referred to the people they want them to get referred to.
It's such a shame that that actually happens because I think, most of us feel some type of loyalty to our employer. We figure, the company's got my back, I've got their back. And that may be the case until you get injured. And then at that point, you become an expense. And I think a lot of times, there's always the exceptions to the rule, but a lot of the times, when you're dealing with an injury, the company is starting to rack up the numbers. They're running the numbers, going, this is going to get expensive. We need to limit this or control it. So this is the kind of game that starts getting played, and the injured employee may not even know.
Exactly, and that's true. The injured employees a lot of times don't know because they think the company is looking out for the best interest, and there are a lot of really, really good employers out there who do that and look out, but there are some bad apples out there. There's bad apples in every business, every profession. You've got a couple of bad apples out there, and they're that way in regard to workers' comp too. There are some bad apples out there from that tried to do that. And part of the reason for it, because some people say, well, why does it matter who you go to? I think part of the reason for that is their premiums get affected by lost time injuries. So if they send you to a doctor who doesn't take you off work when your family doctor would have taken you off work to let you heal from this injury, and their doctor puts you on light duty and they bring you back in light duty, it doesn't affect their insurance premiums as much from that standpoint. Now, I think that's part of the reason why they do that. I think some of the insurance companies do it because they know if you control the medical treatment the person gets, you can affect how much money the person gets on the back end when the case is resolved as well. So that's the reason the insurance company's wanting to do it that way. But you shouldn't let them do that. And in fact, my advice whenever a client, first off, whenever you're injured and you get this form, that's one of the triggers you should say, okay, I need to reach out and talk to an attorney to find out what I need to do here. Because when you do that your choice here in making these changes can have an impact on what your attorney can obtain for you later on in the case. Judges tend to pay more attention to treating doctors than they do to non-treating doctors. They know the insurance company can send you to a doctor who's going to say your problems aren't as bad as they may really be, or your problems aren't work-related when they really are, and vice versa from that standpoint. So they tend to give more credence to treating doctors. So if the insurance company controls the treating doctors, that goes a long way toward affecting the ultimate outcome in that case.
Would it be a good idea maybe to designate your family doctor? Is that and do all family doctors deal with workers' comp? I know some don't deal with insurance issues related to like accidents, car wrecks, things like that. But what's your experience?
There are some family doctors that don't deal with workers' comp. There's not a lot now. There used to be more who didn't deal with workers' comp, but most of your, at least locally, I see a lot of family practice clinics where you have multiple doctors, and nearly all of them will accept workers' comp. There are some who may be by themselves. They have their own office and they're the only doctor there and some nurse practitioners. And they're more, those are the ones I tend to see that don't accept workers' comp. Not saying all of them don't do that, but there's some, that's the ones I tend to say where they don't accept workers' comp because workers' comp is more paperwork than regular health insurance is. And in workers' comp, you've got them overlooking the doctor's shoulder and saying, "No, I know you think your patient needs this treatment, but we're not going to pay for that treatment. You're going to have to do something different." And doctor, I wouldn't like that practicing law. Someone looking over my shoulder and saying, "No, that's not the way you ought to practice that case," even though I've been doing it for 30 years and think I know what I'm doing. From that, and it's the same. I know that has to be extremely frustrating to doctors as well. And so, and a family doctor who's got more than enough patients already and they're by themselves are at least less likely to accept workers' comp. But what I see generally is most doctors do accept workers' comp now.
And that could be a quick phone call before you fill out the form to say, "Hey, doc, are you okay with me putting you down this way?"
And you need to.
Because you don't want to use up one of your options. You don't,
Well, the doctor's got to accept, so it doesn't. It's not a valid election until the doctor accepts being that way. So, but you need to call the doctors up, and you said exactly what I tell clients, and that is choose your family doctor to be your designated doctor. And the reason you do that is that your designated doctor can refer you to any specialist they feel that you need to see, and it can be of the same type. So if you want to be referred, if you need to be referred to an orthopedic surgeon, and so the doctor refers you to an orthopedic surgeon, and you go see that orthopedic, and you and that orthopedic just don't get along for whatever reason. You don't like that doctor, you don't trust that doctor. After you saw him the first time, you mentioned to a friend, and that friend said, "Oh, I've heard bad things about him." You don't want that doctor treating you. Whatever reason you don't want to stay with that doctor, you can go back to your family doctor and say, "I wasn't pleased with Dr. Joe Blow out here. I'd like to go see another doctor," and then the doctor can refer you to a different orthopedic. And the insurance company can complain about it, but there's not a lot they can do about it in that situation because they're not controlling your family doctor from that standpoint. So that's the reason I tell people use your family doctor and never ever designate a specialist as your designated doctor, because if you get dissatisfied with the specialist, you may find one who's going to refer you to another specialist that does exactly what that's the same type of specialist that they are, but it's not going to occur a great deal. At least I haven't seen that occur a lot in my practice. From there, so designate the family doctor and leave it as your family doctor from that standpoint. But when you get this form, it's going to be sent to you. That's what you need to do. Even if they've sent you to the plant medical, their doctor, occupational medicine, or it could be a family doctor. Now, if they send you, if you go to your family doctor's clinic, fine, you're good. There shouldn't be any problem designating your family doctor. If they sent you to a different clinic full of family doctors, then call your family doctor up and say, "I suffered this injury on the job. I've got I need a designated doctor. Can I come see you? Will you be my designated doctor for this? And if I need referral specialists, you take care of doing those referrals." Hopefully they're going to say yes. Then you go in to see them, have them sign the paperwork, send it back in, and everything should be fine.
Well, I guess part of the strategy there is the trust in your family doctor to really kind of have your best interest at heart, have your full healing as a primary focus rather than controlling dollars and expenses on the backside of the forms and for the workers' comp claim. I mean that doctor as your family doctor is probably going to have a little bit of a history with you, kind of understand what you're dealing with, and probably be able to focus on you.
Exactly, and that's where there's a couple of benefits of having the family doctor there. One is hopefully you have that relationship with the doctor, and that doctor's going to look out for what's in your best medical interest and not be as concerned about the insurance company saying, "Hold on, what about this, what about that, and just say, this is my patient, this is what my patient needs, that's what I'm ordering from that standpoint. And the other side to that is, and I've seen this frequently in my career where someone, they're at work, 55 years old, they're at work and they lift something very heavy, have an onset of back pain, and then they go to a company doctor. The company doctor, insurance company, gets all the medical records, including the family doctor's medical records, and finds out 6 years ago they went to the doctor and they had complaints of back pain, and then the company doctor says, well, I think this may be a pre-existing issue. Whereas when you go to the family doctor and family doctor looks at it and says, yeah, he had back pain, but I diagnosed that as a kidney infection. We treated it with antibiotics, and it wasn't really a back problem. It was an infection. His pain was there, and so it was noted as back pain. This is a completely different condition than what that was. And I've had that occur. I've dealt with that in depositions with doctors where they say, well, he complained of back pain 5 years ago, 6 years ago, so how do I know this isn't a continuation? And then I'll point out, what was the diagnosis then? Kidney infection. Can kidney infection cause back pain? Yes. Is that completely different than what he's got now? Yes, this is not a kidney infection. This is a herniated disc. And they look like they quickly say, well, yeah, if that was a kidney infection, this is completely different. This is a new condition. But unless you go in there and you get those records and you look at it, and then you've got to go take the deposition, increased cost, and time consumed, and causes more problems for the injured worker in that setting. So if you can avoid that from the beginning by going to your family doctor, saves a whole lot of problems and headaches down the road.
Well, as you've explained in the past, part of the reason they're looking for that connection to a pre-existing is to try to shift some of the blame. Hey, this isn't all work related, so we shouldn't be on the hook for all of it, right?
Correct. Exactly. That's exactly what they're trying to do in that setting. And I need to make sure I'm clear on one thing, because I said in Kentucky you're allowed to choose your doctor, and that is 100% accurate. But in Kentucky, the insurance company can have a managed care network. And so if they have a managed care network, you get to choose your doctor, but it has to be a doctor within that managed care network. And that's the one instance where your family doctor may not be available, because if they have a managed care network, and I'm just going to use a couple of clinics here in Murray, but and your family doctor is at Village Medical, and Village Medical is not in the managed care network, but Murray Medical Associates is. You may have to go to the family doctors at Murray Medical Associates instead of your family doctor, just because your family doctor's group isn't part of that managed care network, and you have to stay within that managed care network. You get to pick within that managed care network, but you have to stay within that managed care network. And that's another reason to reach out to an attorney to talk with them, because, when you've done this for 30 years, 31 years, like I have, which doctors tend to be more listen to the insurance companies versus the doctors that said, this is my patient. I'm treating my patient the way I think my patient needs to be treated. And insurance claims representative, you're not a doctor. You're not going to tell me how to treat my patient. And, we know that because we've dealt with that a lot, and that can help. And especially if you got to pick somebody besides your family doctor, that it's a good idea to know which doctors you want to kind of steer away from.
Well, for a lot of people, when they get hurt on the job, that might be their first significant injury that's job related. I mean, yeah, we've all done things, but maybe that's the first job related. So all of this is brand new to them. And with your experience, having done this for over 30 years now, you have a pretty good idea. Okay, this type of injury, you're typically going to need these tests. You're going to probably need this. We're going to defer to the physicians, obviously. But you've got a general idea of what should happen. And when those treatments or exams or tests are being denied, your red flags go up.
Correct. Exactly. I do. I see a lot of different doctors' treatments out there. And, my overarching goal is to do the best I can for my client in their workers' compensation claim. And the best way to do the best job for my client is to get them the best medical treatment so they have the best recovery they can have from that standpoint. So if I, there are some things that if it's recommended to my client, I may talk to them about, you might want to get a second opinion on that. Or if it's not being recommended, I may say, you might want to get, go talk to somebody about getting an MRI done before we resolve this claim, because I want to make sure we're not missing something there. So at times you can do, those aspects come into to play in having an attorney who's done what I've done for so many years and have seen the different treatments from doctors all over West Kentucky, Nashville, Louisville, Lexington. I will share that information. I don't tell my clients what treatment to get at all. I'm not a doctor. I don't recommend treatments to my client, but I do occasionally tell clients that you might want to talk to somebody else just before you do that, or let's see if we can get this test done before I resolve the claim, because I don't want to resolve the claim and then 6 months later they do an MRI and find out there's more problems than what we thought when we were resolving the claim.
This is, again, another reason why often you'll hear attorneys referred to as advocates. You're going to advocate for the patient's best interest, the client's best interest. And I think, again, you combine that with over 30 years of experience, and it's just another safeguard for the injured worker and his or her family. That's one of the best things about having an experienced attorney who knows this area of the law.
I agree, and that,
I thought you might.
Part of that too is because I have clients come in, and they don't want to stray very far because finances are tight. Right now, everybody's finances are tight. And so I have some clients that don't want to go to Nashville to see a neurosurgeon down in Nashville because of mileage. And that comes into the other form that we were going to talk about, which is the Form 114, which is the reimbursement. It's a reimbursement form. And a lot of people, when they get injured on the job, they're not advised by the insurance company that they're entitled to get reimbursed for certain out-of-pocket expenses, one of which is mileage, the big one of which is mileage. So a lot of clients, when I talked to them initially, and I asked them, have you been submitting your mileage? And they look at me like, what are you talking about? And I explained to them that your mileage going to and from the doctor's offices, you can get reimbursed and should be getting reimbursed for that. There's a certain form you're supposed to submit to get that reimbursed in that standpoint. So, and that makes it with some clients saying, okay, I'm more comfortable going to Paducah or going to Nashville or going somewhere else to get a second opinion or to see a super specialist for their problem, because they know they've got, the mileage isn't coming out of their pocket. Right. And so that's something in the Form 114, you can use that to get reimbursed your mileage, as I said. Also, initially, a lot of times when people have an injury and they seek medical treatment, before the workers' comp insurance is even aware of the injury, they may have a prescription from the doctor that they go to initially, and they go get that filled. Well, the pharmacy is not going to fill it with not knowing that workers' comp is going to pay and have some assurance. They're going to submit it in on the health insurance, and the person's going to have to pay a copay. Sometimes they have to pay a copay at the initial doctor's visits, and that gets reimbursed and taken care of as far as later on. But the way the injured worker gets reimbursed is with that Form 114. You submit your receipts and all where you paid out of pocket for the prescription or for the doctor, the copays, and then the insurance company should reimburse you that, and the mileage, submit the mileage on there, and the insurance company should reimburse you. One thing to remember, though, on that form is you're supposed to submit those reimbursements every 60 days or within 60 days of the expense being incurred from that. Now, there are some question under Kentucky law right now on if that 60 days applies prior to an initial judge's decision saying your injury is compensable. There's a case that says that it doesn't, but there's been a recent case that kind of calls that into question to some extent. So, used to you could get by, and I'd get clients in that 6 months, 8 months, even a year out from the injury, and we could submit the mileage and get it reimbursed then, even though it had been a year since the mileage had been incurred. Less likely to have that occur now. So injured workers need to make sure they get that form and they submit that form every 60 days so that they're getting the reimbursements that they're entitled to get.
And that form doesn't come back to you at the Roberts Law Office. That goes into the insurance carrier?
Goes into the insurance carrier, and a lot of times I'm not even involved, even for my clients. The initial one we will go through and show the client how to fill that out, and then we'll give them multiple copies of that and let them know, submit this in every 60 days, keep a copy for your records. If you don't get reimbursed, let me know. But frankly, most of the time, if you're submitting them every 60 days, the client's getting that reimbursement, and they don't even have to go through our office to do that. And, I've got clients, as you know, I've got clients that live in Louisville, Bowling Green, Hopkinsville, which I have an office at, Paducah, and all over. And to get me those forms, they'd have to put it in the mail to me for me to get the form, a lot, because it's got to have their signature on it. So it'd take 7 to 10 days to get to me, and then me send it into the insurance company. I can scan and email it most of the time, but still, if you're waiting to day 45 and then you mail it to me and it gets hauled up in the mail for whatever reason, I may not be, I get it in at day 55, or day 62, and we're too late. Or if it comes in over the weekend and it's day 61 when I come back in on Monday and see that. So I just tell client, you submit it in. After that first one, we show you what to do. If you don't get reimbursed, contact me, let me know. But the vast majority of the time, the client gets reimbursed, and I don't even have to get involved in that fact.
Well, I remember a few weeks ago, back in episode 64, we talked about this briefly. And, there's also a question of it's more than just mileage that can be reimbursed. I mean, depending on the situation, a hotel expense may be reimbursable, some meals possibly. But again, there are some cautionary advice that you might want to give people about that.
Correct. Yeah.
Don't just assume you can go stay down at the Hilton just for the fun of it, right?
Exactly. And it's going to be a reasonableness standard on all of that. If you've got a significant hand injury and you're treating with Kleinert and Coots Hand Care Center in Louisville, who are some of the best in the world for your hand injury, and you're from Murray, Kentucky, and you've got surgery at 7 o'clock in the morning, you got to be at the hospital in Louisville at 7 o'clock in the morning. Well, you're losing an hour because you're going to Eastern time. Time you'd have to get up to drive to get up there it's reasonable in that situation to get a hotel room in Louisville the day before surgery, get up, go to and a lot of hospitals have agreements actually with hotels close by where people get special rates in that setting. And then you can go get your surgery, and if it's outpatient, come home afterwards, whatever it is. In that type of situation, the hotel room's going to get reimbursed. Now, if you go try to stay at the Ritz-Carlton, you're going to have a problem with that. But if you're staying at a reasonable hotel close to where you're getting the procedure at, or a reasonably priced hotel for that location, you're going to be fine in that regard on getting the reimbursement from the insurance company in that setting. And the same for meals. There. Now, again, it's not going to pay for you eating at Jeff Ruby's, a
big steakhouse,
go get a $70 steak somewhere. They're not going to reimburse that, but reasonable expenses for meals would get reimbursed in that setting. Some insurance companies will reimburse if you've got a spouse that goes with you, and most will. I've had a few balk at times if it was for something where the person didn't need a driver. If you're having surgery and going to need a driver coming home, then you're going to get that reimbursed without much problem. But if it's a situation where you don't really need the driver, but you've got to go to Louisville for a doctor's visit, and your spouse goes with you, I've had some insurance companies balk saying, well, the spouse just went because they wanted to go. They weren't required to be a driver for this visit, so we're not going to pay. A lot of times they don't really fight over it, but occasionally they will. So, it's comes down to being very fact specific in those situations.
Just be reasonable.
Yeah.
And exercise some caution. And I guess they could call you ahead of time and say, hey, Jeff, what do you think about this? And you could probably advise them a little bit.
Yes. Yeah, exactly.
Outstanding. So again, today we talked about some of the forms that you're going to receive when you're opening up your workers' compensation claim, and that you'll usually receive these from the insurance company itself. That's Form 113, which is the designated physician's form, and then also Form 114, which is your basic reimbursement form. And that's used to, again, get paid back for mileage and some other miscellaneous expenses you may incur while you're getting treated for your workers' comp-related injury.
Yeah, the Form 114, some insurance companies do send those out. Some do not send those out and don't tell you that you can get reimbursed mileage. So I think you mentioned earlier you're going to put the link to where you can get those online. And so if they don't send that, click that link, go online and get those so you can print it out and fill it out.
Outstanding. Jeff, I want to thank you for your time again. I appreciate it. And this is some of that inside baseball talk. We talk a lot of times about different factors related to workers' comp, but actually the paperwork is a big part of it.
It is. And it can, especially like that Form 113, it can make a huge difference on the back end on who your designated doctors or who your treating doctors are. And on the Form 114, I've got involved in cases where it's been, a few years since the injury and the mileage hadn't been submitted, and that can, it can rack up to, $1,000 or more, depending on the treatment a person has or does receive, physical therapy and things of that nature. And so that can be a major expense that you're not getting that you should be getting if you don't submit those forms.
Just remember that 60-day window, right?
Exactly.
Absolutely. Hey, Jeff, once again, thanks for your time. We'll be back in a couple of weeks, my friends, and we encourage you to check us out and check out Jeff's Facebook page, by the way. The Roberts Law Office has a really nice Facebook page where you'll find this information posted, but you'll find other information about the practice and other topics that come up from time to time. And that's it for this episode. We'll be back in a couple of weeks.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.